freedom of religion and education is a very vast subject, and I will try to go straight to the essential to clarify the current issues with an historical perspective. I think it's important in transitional periods to have some vision from the history. Education and religion are tightly linked. As you know, the Church, the Catholic Church, has been the teacher of Europe for centuries. In Europe, knowledge was preserved and cultivated within monasteries during the Middle Ages. And the classic heritage was transmitted mainly through the Renaissance period through religious heritage and institutions. The great minds even of modernity like Erasmus, Descartes, Pascal, Spinoza or Kant are the heir of the religious faith, culture and tradition. In this tradition, knowledge can spread under all its dimensions. The secularization of teaching and education is a quite recent and incomplete phenomenon. It is only with the emergence of the atheistic and rationalist school of thought that education and religion were presented as incompatible. The pretension of rationalism to explain everything negated the epistemological legitimacy of religions. Contemporary Europe inherited this conflict, which intensified with the fight of secular schools against religious teachings, as evidenced by the dramas of the first half of the 20th century, marked by the prohibition in France of the teaching congregations by the French Republic in 1901, and by the prohibition of religious institutions, educative institutions by the Soviet and Nazi regimes. The first half of the 20th century was marked by a will of the state to have a strong hold on the youth through the schools to impose its ideology. At the end of the Second World War, European states managed to overcome this conflict, which was internal to the European culture, in accepting to guarantee freedom of conscience and religion and to respect the rights of parents concerning the religious teaching of their children. Against a statist and totalitarian system which imposes itself from the government to the people, from the top to the down, the writers of the Universal Declaration of Human Rights and of the Convention and its first protocol have sought the balance point in the relations between the child, family, communities, society, and the state. This was realized in a cultural context marked on the one hand by a positive vision of family and also of religions, and on the other hand, on a negative vision of the state and statism. The solutions of 1948 and 1950 relies on the organic and natural comprehension of society according to the mode of subsidiarity. The aim was to rebuild the society from the base, bottom up, basing it on persons and families. Family is then recognized, as you know, as the fundamental and natural unit of society. So, naturally, the Universal Declaration declares that parents have a prior right to choose the kind of education that shall be given to their children. This priority is the expression of the precedence and superiority of the rights of parents on those of society. It is exercised against the state and all other social groups. The role of the state is subsidiary. It must not substitute itself to families, but on the contrary, recognize and help them in accomplishing their own responsibilities and, if necessary, supplement the failings of parents when children are deprived of proper education. This is the spirit that animated the writers of the Convention and its first protocol when they recognized the right to education in respect of the rights of parents regarding their religious and philosophical convictions. The travaux préparatoires of the Convention and its first protocol clearly show that the first aim of their authors was less to proclaim a right to education than to guarantee this prior right of parents against the state. The rights of parents are then, in the travaux préparatoires, often called as natural, elementary, fundamental, innate, or priority rights. This right, which was initially considered to be the third paragraph of Article 12 of the initial project of convention, was not entitled right to education, but was called the prior right of parents to choose the kind of education to be given to their children. This was one of the, I quote, family liberties, with the right to marry and found a family, and the right to privacy. As underlined by numerous drafters of the convention, it was aimed at protecting families against the danger of, I quote, nationalization of young people by the state. In its report of December 1951 by the Committee of Legal Affairs and Administrative Questions of the Assembly, in charge of drafting the protocol, insisted on the fact that the right to which parents can and should be entitled extend not only to the education, but also to the teaching given to their children. The rapporteur of this committee, Mr. Teger, precised that the text must hence guarantee, I quote, the fundamental rights of all parents to have their children brought up and taught in accordance with the dictates of their own conscience, whatever they may be, and it is not for the state to judge. End of quotation. Based on these natural and liberal principles, the court developed the right to instruction, including for ethnic, religious, and linguistic minorities, underlying the importance, inter alia, of pluralism and tolerance. The situation nowadays has changed. Between 1950 and today, as you know, the context has changed. Society in 1950 was mostly homogeneous. It is not the case anymore. We saw the burst of the institution of the family and the drop of Christian practice, and also the correlative rise of individualism. In an individualistic society, subsidiarity is not really possible anymore. Nowadays, the Western society has a largely negative view of religions, the opposite from 1948, and a largely destructured experience of families, the opposite from 1950. Yet, within the majority population, minorities and immigrated populations seem exempted from such trend and keep constituting alive communities, but distinctly from the majority. Those minorities do not integrate the postmodern liquid society described by Zygmunt Bauman. The disaggregation of the subsidiary society indeed strengthens the state, which then appears to be the ultimate factor of cohesion. At the same time, traditional communities, while becoming a minority, are more isolated but also more visible. Like lumps in the liquid society of individual relativism, they face increasing hostility. What is the answer? When the social cohesion of society is weakened, school becomes again a major political issue. What is at stake for the state now is not to support the cohesion of society, but also to struggle against its disaggregation. Once again, this is a top-down social process consisting in imposing integration, notably through forced modernization, which sometimes goes through forced secularization. In some of its judgment, the jurisprudence of the European Court took that path by approving the reinforcement of the power of the state against religious expressions within teaching institutions. The Court hence admits that the role of the state is not limited anymore to ensure about the quality of the teaching and the respect of the health of the children, but that it can reach to the expressions of religious convictions and even to the contents of moral convictions of pupils and students. It was first seen in the acceptance of the prohibition of wearing religious symbols within teaching institutions. It was even more spectacular in the recent Osmanoglu versus Switzerland case from January 2017, in which the court poses the principle, the far-reaching principle, that the interests of the children in a full education enabling a successful social integration according to local customs takes precedence over the wish of the parents. This ruling from last January confirmed a previous ruling from 2006 against Germany when the court accepted the prohibition of homeschooling, also in the name of the need to integrate minorities within the society. In my experience, and respectfully said, these judgments are problematic for a liberal society, where it considers that from a top-down approach, the societies, the communities shall be, in some extent, forced to integrate against the will of the parents. As a conclusion, I would say that there is a limit, of course, not to a path for a society to remain liberal. In today's circumstances, when we are looking for a solution for keeping the cohesion of the European societies, I think it is essential to remind what have taught us the writers of the Convention and of the Universal Declaration of Human Rights. Cohesion of society cannot be imposed by force in one day. The best way to prevent conflicts and to build cohesion and peace, social peace, is, in my experience, in my view, to respect the natural laws of societies, which is mainly expressed by the principle of subsidiarity. As an ultimate conclusion, I would like to recall a lesson that comes straight from the Middle Ages. When questioned on the possibility to remove a child from his Jewish parents in the Middle Ages, for the best interest of the child to be baptized and to be integrated into the society, which was Christian in that time, Thomas Aquinas firmly opposed this in the name of the priority nature of the natural rights of the parents. Thus, he then, in the Middle Ages, explained us that the public freedoms essentially consist in guaranteeing the natural laws of society. Thank you.
Thank you very much.